So the rent section says, if you owed rent from March 1st to September 1st, 2020, then the landlord has no right to even ask for that until February 1st, 2021, if the tenant fills out a declaration. So the landlord has to give a declaration along with notice of rights to the tenant. All the tenant has to do is sign the declaration that the landlord gave to the tenant and return it, and then the tenant is fully protected from March until September. Now, from September 1st onwards, the law says that there's a 25% rent payment that's due, but if the tenant returns that declaration, but the tenant does not have to actually pay it until February 1st. So to me, that's the same thing as saying the tenant doesn't have to pay anything. And I'll just give you the bottom line with regard to rent. I've got since September 1st, I've done about 35 eviction cases in Ventura County. Every single one has been for something other than rent. It's basically impossible. If the tenant returns a declaration and says, I'm affected by COVID, doesn't have to be true, doesn't have to be verified, the tenant just has to sign his name on the declaration that the landlord gave to you, that tenant is fully protected until February 1st. And let's say that the tenant doesn't return the declaration. The tenant just doesn't even bother to sign it. You file an eviction lawsuit seeking unpaid rent, and then the court case starts. You paid court costs and attorney's fees to start the case. If the tenant returns the declaration after the court case starts, the court's almost certainly going to give the tenant a second chance.
Let's say that you win the case on an eviction. Right. How long does it typically take to get the tenant out from that point? Hi, everybody. This is Jose Luis Morales. Welcome back to the Morales Group Show. This is episode number 44. Today we have a repeat guest. His name is Brian Nomi. He is an attorney here in town, specializes in bankruptcy and tenant law, and I think a couple of other things. So today our topic is going to be what to do if you're a landlord and you're in a situation where your tenant is not paying, and basically you think that you can evict them. So we're going to be going over some different topics. We're going to be going over some different insights. Brian's going to be sharing his expertise. So welcome to the show, Brian. How are you?
I'm doing wonderful. Thank you for inviting me on your show.
Of course, man. Anything to provide value to the end consumer. So let's get started. Let's just start off by talking about like some of the basics of California tenant law. Like, can you explain that? And then how has that changed over the last year as well, too?
Yeah, that's an excellent way to get started. I'll start with the basics. Then there's going to be three parts to my talk: basics, and then 1482, which went into effect in January. Most people are familiar with 1482. And then 3088, which went into effect on September 1st. Okay. So the basics of California law are, you own a property of some sort and you want to rent it out to make money. So you enter into a lease agreement, which could be a written or it could be a verbal lease agreement. Both of them are legal in California. There's no reason that you have to have it in writing. I recommend you have it in writing.
Yeah.
What is the property that's being rented out? How much is the rent? What are the rules that both sides have to obey? And there's a whole bunch of law that's developed over the last 100 or so years in California as to what landlord-tenant law is. So under the normal California law, if the tenant breaches the lease or does not pay rent, that tenant could be subjected to a 3-day notice to pay rent or quit. Mm-hmm. The alternative to that is that if you just don't want the tenant to live with you anymore, you don't even have to give a reason. You can give either a 30 or 60-day notice to vacate. And with no reason at all. The only exception is you can't do it for a discriminatory reason. Like you can't say, I want you out of my house because you're black, or I want you out of my house because you're Jewish. You can't discriminate on the basis of a protected class. But if you just say, I don't like you because I don't like you, that was perfectly legal under California law. And the rule was if the tenant had been there for less than 1 year, 30 days notice is all the tenant gets. Whereas if the tenant had been there for more than a year, 60 days notice. So that was the law for the last 10 years or so. The law was changed from 30 days to 60 days for tenants of more than 1 year. So that's the baseline that we're talking about. Any questions or comments about what was the law before?
No, I mean, I think that was pretty in-depth and pretty self-explanatory. I think where people are going to have most of the questions, Brian, or the 1482? How did the law change at the beginning of the year? And then what is the law right now? I think that's where most of the questions are basically coming in.
That's where all the questions are coming in that I'm seeing. So on January 1st, before COVID-19 virus emergency even happened, that's when 1482 went into effect, January 1st, 2020. What does 1482 do? I mean, I just call it 1482. It's the Protecting Tenants Act of whatever. Two things, rent cap and just cause. The rent cap means that the landlord cannot raise the rent by more than 5% plus the cost of inflation, and that varies county by county, city by city. In Ventura, most of Ventura County, it's about 3%. So in other words, the landlord can at most change the rent by 8% per year. So the maximum that you can raise the rent is 8% in a 1-year time period. That was the first part, which is the rent cap. The second part is the just cause. In other words, the landlord cannot evict unless you have a just cause. And so what are the just cause? The just cause could be failure to pay rent. The just cause could be illegal activity. The just cause could be a number of other things. And I'll just read over what they are. Maintaining, committing, or permitting a nuisance, committing waste, such as destroying the property, termination of a lease. In other words, the lease has ended by its own terms. Like you got a 12-month lease that goes from January 1st to December 31st, that lease is ended. That's another reason that you could end it. Criminal activity, assignment or sublease in violation of the terms of the lease, refusal to allow the owner to enter the property, using the premises for an unlawful purpose, or termination of the tenancy because of employment. In other words, some housing is conditioned upon employment. The only reason the tenant gets to live there is because the tenant is employed. When the employment ends, then the tenancy also ends. So that's how that would work. So that's the just cause part of it. Now, there are exclusions from this. You can be exempt from the rent cap just cause laws under 1482 if you have a single family house, a condo, which is separately alienable, or a duplex in which the owner lives in one part of the duplex. So those are the main exclusions. The other part of the exclusion is that you cannot be a corporation or a real estate investment trust. So if it's just an individual or a family trust, or even an LLC, which is small, a small LLC, which is how a lot of people own their real estate nowadays, those entities would be protected. Typically I call them mom and pop, like a person or a family that owns a house or a condo, they could be exempt from 1482. But you have to make sure that you notify the tenant either as a term of the lease or through an addendum to the lease that they will be exempt from the rent cap and just cause provisions of 1482. The other part of this that I wanted to mention is that this 1482 does not apply to commercial tenancies at all. No effect on commercial tenancies. In other words, if it's not residential, if it's a business lease, 1482 does not apply at all. So anyway, that's a quick 3-minute tour of 1482. The rent cap provision is the big thing. The just cause exclusions for the reasons are the thing that you need to know. There's all the reasons, such as illegal activity and all the rest. You can be exempt from it if you're a mom and pop owner and it's a single family or condo, separately alienable property, or duplex in which you live in one part of the duplex. If it's a multi-family unit, such as an apartment building, a fourplex, triplex, anything like that, or if you're a corporation that owns the property, you're going to be subject to 1482. So that's what we're dealing with. That's the new landscape of California, and that's going to be probably permanent. The law is in effect until January 1st, 2030. It's probably going to get extended 10 years from now. That's what I think about 1482. California is just making things a little more protective for the tenants nowadays. I think that's going to be a permanent fixture of California law. One thing I want to tell your listeners is if they have a lease, make sure that if you do a new lease and you're able to, make sure that you have a 1482 waiver. There's certain magic language that you can put in your lease that makes it so that 1482 does not apply to your lease. So if you want to kick out the tenant because he's just a bad guy, but you don't have anything specific, no specific violation of the law, you want to be able to have that right. So make sure that that's in your lease going forward. If you haven't thought of that already, the way that you get around that is by giving a 30-day notice of change of terms and then a rent cap just cause exclusion. These are all CAR forms that are easy to get. And do that now before there's a problem is what I would suggest to people. I'm more than happy to share those forms. They're CAR standard forms, so they're pretty easy to use. You just check the right box, fill in the name and address of the tenant, and that will get you out of the 1482 box, so that you'll have more freedom as a landlord in terms of being able to terminate the lease if you want to. So that's 1482. Questions, comments about that before we move on to 3088?
Yeah, and I want to encourage anybody who's watching, if you guys have questions about 1482, to just drop them in the comments, and we'll address them at the right time. I actually made a couple of questions. So one of them is payment. So is there a certain circumstance where a landlord, if they want to evict a tenant, would have to pay relocation cost, and what would that
Yes.
look like?
Yeah, that's an excellent question. I went through it so fast I didn't even mention that. In addition to the fault reasons, I skipped completely the no fault reasons, which is even if you are subject to 1482, you can still terminate a tenancy, but you have to give 1 month relocation. And the reasons for that would be family move-in. So, for example, you own the property, it's being rented out, but you want to move in, or you want to have one of your family, like your children or your grandparents or whatever, they want to move into the property. That's a family move-in. You're withdrawing the property from the rental market. You intend to demolish or remodel the premises. You're doing something so major that you can't do it with the tenant still in there. Or that you plan to sell the property. You're selling the property. So those are all reasons that you can give a no-fault 60-day notice of termination, but you must give the tenant 30 days of relocation money. So if you don't want to give the 30 days, that's another 30 days of free rent. Well, there's two ways to do it. One, you can give the tenant cash up front, or second, you can give the tenant the last month free. Every landlord that I've ever seen just gives the tenant the last month free. That's just a smart way for the landlord to handle that. If you want to get around that, make sure you give them the rent cap just cause addendum to get yourself so that you don't have to pay that extra consideration to the tenants if you want to remove the property or give it, rent it out to your brother or your son or whatever. So that's an excellent point. Those are the no fault reasons that either a mom and pop or a corporate or multi-unit landlord can possibly terminate tenancy without any bad conduct on part of the tenant. It's just we want to do something else with the property. That's all.
Okay. So
excellent.
I think where the questions for me are in that is it seems like there are some gray areas as it relates to that. What I mean by that is that like substantial renovations, like what does that exactly mean? And also, like, I say that like I want to gain possession back because my mom is going to move back into the property, but then my mom doesn't end up moving into the property, and now the tenant has vacated. Like, what happens in the situation? So, can you elaborate a little bit on this?
Yeah, I mean, every one of these provisions is a little unclear to me as well. I mean, what does it mean to say the owner intends to withdraw the premises from the rental market? To me, that just means you're not going to rent out the property anymore. If you're intending to sell the property, in my mind, that means that you're withdrawing it from the rental market. But one specific thing that you asked was, what does it mean to substantially remodel or renovate the premises? There's actually some legislative history that I've looked up on this, which says that it's a major renovation that requires a building permit. So that's one bright line right there. You have to have a permit. It's not just putting paint on the walls. It has to be something major enough to require actual permit from the local authorities. The family move-in you mentioned, I don't know of any police agency anywhere that's going around to make sure that someone is still living there for a certain amount of time after you've had the tenant move out. Potentially the tenant could come back or hire a private investigator or whatever and find out that your family member is not living in the property and potentially sue you. I have never seen that happen. But I'm sure somewhere in California it's going to happen. And so, I would never advise a client to lie to the court and tell a lie when they're not actually going to have their parent move into the property. Excellent point. How hard is that going to be fought over? I'm sure that there's going to be some cases where people are going to fight like hell over these issues. This is we're talking about kicking people out of the house where they live. It's going to be a hotly contested issue, no doubt about it. And so my advice to people is make it as clear as possible. I mean, if you're planning to sell the property, there's a specific provision that allows you to sell the property. Make sure you follow that. If you're going to have your parent or son or whatever move in,
Mhm.
Make sure that your parent or son really moves in for at least a year. And in fact, it even says for 1 year after the tenant vacates. So, that's the time frame that you're looking at as 1 year for that. If you're going to be rehabilitating or remodeling, make sure that you're doing something that requires a building permit. So those are the things that I would say are more specific for the no-fault reasons that you're terminating a tenancy under the 1482 provisions. But that's a great point. Very good point.
Now, the other question that I had about this before we move on to the coronavirus stuff is who is exempt? Like, I know that you kind of briefly touched on it. So
Yeah.
it's single family residences, condo and townhouses, and then anything that is over 3 units would not be exempt if I have it correct.
Yeah, even if the owner lives there. Yeah.
Even if the owner lives there. And then also, you said something about small LLCs or family living trust. Like, did I hear that correctly, or is
Yes.
that?
Let me get you exactly what's going on with that. Hang on for just a sec. Okay. I'm sorry to keep you on hold here, but I can get you exactly.
Okay, cool.
Let's see.
Yeah, because I thought like any LLC, as long as it's an LLC, was not exempt, meaning that they have to follow the rent control and the just cause.
So the owner can't, in order to be exempt from 1482, the owner cannot be a real estate investment trust, a REIT,
Mhm.
a corporation, or an LLC in which one member is a corporation. That's the specific text of the law right there. So you can have the property be owned by a mom and pop LLC, which is a very common way of owning real estate. That's fine as long as, Acme Corporation is not a member of the LLC, which I don't know of any family that owns real estate in an LLC that has a corporation that is a member of the LLC. So
Yeah. Okay.
basically every LLC that I've ever seen is cool. You can
Okay.
be an LLC or own it in your family trust, and you would still be exempt as long as it's a single family or a condo. Something with separately alienable title, single family and condo.
Perfect. That's great.
Yeah.
Okay.
Yeah.
Good.
Great. Thank you for that clarification. Make me be a little more clear on that. That's good.
So let's jump into okay, so that was January 1st, 2020.
Right.
Now it changed again, right? So I think
Right.
that's where a lot of the even more of the confusion came into effect. Now I hear that just cause is basically for everybody now, regardless of whether you're a mom and pop shop or anybody, that with the coronavirus, at least through this pandemic, it's for everybody. So can you go over some changes that have taken into effect since the coronavirus Tenant Relief Act, and what is it like?
That's a great segue to the last part of this, which is, in March of 2020, this year, that's when the coronavirus hit. And, lots of people were ordered to stay home. Lots of institutions were ordered to shut down. And I'll just tell you, from about March 15th or March 17th until September 1st, 2020, it's a period of about 6 months, the courts in Ventura were processing almost no evictions, with very, very limited exceptions. So no evictions at all, pretty much, for the whole county, for the whole state. I mean, if not nationwide. Finally, in September 1st, there was a legislative compromise that was reached. I mean, there were people who wanted to keep the eviction restrictions in place well into next year, but a compromise was reached to allow some evictions to happen and under certain circumstances, and that's what we call 3088. That's Assembly Bill 3088 is what's happening right now. So that's the law as of September 1st, which is Assembly Bill 3088. It's a very complicated piece of legislation. I've read it like dozens of times. I've read summaries of it. And honestly, I don't fully understand all of it. There's some things that just are not addressed in it, and some things that are completely unclear in it. But the main point, there's 2 points of 3088. The first point is, if you can't pay rent, you're subject to specific protections for rent. That's the first point of 3088. The second point of 3088 is that it extends the 1482 protections to everybody, subject to a couple limited exceptions. So what we just talked about, let me start with the second part of that first. The at fault, you could still kick someone out for an at fault reason. If they're doing criminal activity, if they're selling drugs or they're having a gang that shoots people at your house, that's criminal activity. That's an at fault reason that you can kick someone out. So the same reasons that I just mentioned before, destroying the property, illegal conduct, criminal activity, assignment or sublease. That's something that we get people on fairly often. If they're having unauthorized people living in the property, that's a for-cause termination. 3-day notice. Refusal to allow entry into the unit or changing the locks, or an unlawful purpose, or termination of employment. Those are specific reasons that you can give short termination notices, 3 days generally, and then evict the person after that. So that's the first part of that. The second part of the termination, the no fault termination, is you can still terminate someone for no cause, but it's a little bit more limited. Family moving is still okay. So if you have a family moving, you can give a 60-day notice and have the person be evicted after that. Withdrawal from the rental market. I'm using that quite often because a lot of my owners intend to sell or just not rent anymore. To my mind, that's a withdrawal from the rental market. Intent to demolish or remodel the premises. There's a little clarification on this, which is that it has to be so severe that not only are you getting a building permit, but it has to be to maintain the habitability of the premises. So it has to be a really serious thing that you're fixing the property in order to qualify for that particular exclusion. An order from a governmental agency regarding habitability, which requires move out. In other words, the premises are so bad and dangerous that some government agency has red tagged your unit. And here's the big one. There's a specific provision of law that says if the seller has entered into a contract to sell the property and someone's going to live in that property, the buyer is going to live in the property, and an escrow has been opened, then you only need to give 30 days notice. And I'm using that fairly often for people that just don't want to be landlords anymore. They just want to sell. They want the tenants out as soon as possible. So that's, if you can meet all those, you're selling to an owner occupying buyer and you've opened an escrow, then you can evict after 30 days notice instead of 60 days notice. So that's a big exclusion in 3088, which is very helpful to some of my landlord clients. And I'll just briefly go over the rent part of it. So we went over the fault and no fault causes under 3088. Now I'm going to talk about the rent part. So the rent section says, if you owed rent from March 1st to September 1st, 2020, then the landlord has no right to even ask for that until February 1st, 2021, if the tenant fills out a declaration. So the landlord has to give a declaration along with notice of rights to the tenant. All the tenant has to do is sign the declaration that the landlord gave to the tenant and return it, and then the tenant is fully protected from March until September. Now, from September 1st onwards, the law says that there's a 25% rent payment that's due, but if the tenant returns that declaration, but the tenant does not have to actually pay it until February 1st. So to me, that's the same thing as saying the tenant doesn't have to pay anything. And I'll just give you the bottom line with regard to rent. I've got since September 1st, I've done about 35 eviction cases in Ventura County. Every single one has been for something other than rent. It's basically impossible. If the tenant returns a declaration and says, I'm affected by COVID, doesn't have to be true, doesn't have to be verified. Tenant just has to sign his name on the declaration that the landlord gave to you. That tenant is fully protected until February 1st. And let's say that the tenant doesn't return the declaration. The tenant just doesn't even bother to sign it. You file an eviction lawsuit seeking unpaid rent, and then the court case starts. You paid court costs and attorney's fees to start the case. If the tenant returns the declaration after the court case starts, the court's almost certainly going to give the tenant a second chance. So you're out all this money for starting a lawsuit, and the tenant gets another chance after the lawsuit has started, says, hey, COVID, and I didn't understand what the declaration was. And that's why I was late in returning it. It's basically impossible to kick someone out for non-payment of rent right now. And that's the law until February 1st. The law is just very, very protective of tenants. They don't want people to be kicked out homeless and then potentially be susceptible to being harmed by the COVID virus. So I'm telling all my landlord clients, look for something other than rent. try to find a legal basis that you can use to kick out the tenant other than non-payment of rent. Even though I think in a lot of cases, non-payment of rent is probably the thing that's hurting the landlord client the most. As long as the tenant is, I mean, looking at it from the tenant's perspective, if the tenant is living quietly, taking care of the property, following all the rules, and doing their best to pay rent, then that tenant is protected at least until February 1st. And people often ask me, what's going to happen after February 1st, Brian? My answer is always, I don't know, but I'll give you my guess, which is I think these protections are going to be extended pretty much substantially as they are right now for at least several more months after February 1st. So, if you want to do something, you should probably start the ball rolling now. If it's a 60-day notice that you give now, that 60 days will be over in February. Take action now if you need to. To me, the impact of the legislation is that it hurts the mom and pop landlords, the people who only own one rental or maybe two rentals, and then that one rental stops paying rent, and there's no way for the landlord to make the mortgage payment or maybe the landlord relies on that for their income, just for their own basic necessities. It probably doesn't hurt the corporate landlord that has a 50-unit or 100-unit apartment building. Those people are probably getting government assistance anyway in some form, so they're probably not being hurt at all. So the impact of 3088 is to get the small guy. That's what I think about 3088. What's the total default rate in California? I think that maybe 3 or 4% of tenants are paying almost no rent or no rent. That's probably the rate. Most tenants are probably trying to do a good job, trying to be good tenants. But that it's just that small proportion. If you happen to be a small-time landlord that only owns 1 or 2 rental units, and you're being hurt by a tenant that is not paying you anything and is trashing the place, that hurts you a lot. And so those are the people that I really like to help the most. So I just rambled on for a long time there, Jose Luis. I'm going to give you a chance to interject with your questions and comments.
So I think the misconception, Brian, and we'll make this conversation, I think the misconception a lot of people have is that tenants cannot be evicted right now.
Oh, yeah, yeah.
A lot of people, tenants have that sense of not superiority, but they feel like, oh man, I'm protected by the law, not knowing that if they are doing some of the other things like not taking care of the property, if they are not, if they're in breach of the lease agreement, meaning if they have a pet and the lease agreement says no pet, if they allowing the landlord in with a 24-hour notice when the landlord requested a 24-hour notice. So there are different things, and if I'm understanding you correctly, it's basically impossible to evict somebody that is not for the reason of non-payment of rent, but you can still evict somebody that is not paying rent based on another reason. And that's the point that I wanted to clarify and make it clear to landlords or other people that even though you can't evict them for the reason of non-payment of rent, you can still evict people if they're in breach of one of the other things like subleasing the property when they're not supposed to. So essentially, if understanding Brian's advice, if you're in a situation, you're a landlord, you've got a tenant, I'm not saying for the tenants that maybe are good people and unfortunately have been affected, but I see both sides. I see some tenants that are in a position where they can pay rent, are in a position where they haven't really been affected, and are just basically taking advantage of the law and basically taking the exception that they are protected. And I think those are the people that landlords are really being affected by. The other thing is that if you're going to be selling the property, if you're looking to sell your property and you end up selling it to an owner user and you follow all of the guidelines, all of the requirements that are correct, even if you have a tenant that is not paying rent, you can still get them out of the property, which is great because I'm talking to a lot of homeowners, Brian, and kind of the feedback that I'm getting, well, I'm just going to wait till January 31st because I can't do anything until then. The reality is my advice is to talk to somebody like you and basically explore the options, have somebody like you review the lease agreement and see if there's any other reason that you could move forward on a sale of the property, or basically just get possession back of your property because maybe you're not able to make the mortgage payment. Now, the questions that I had for you. So,
Yeah.
so from March to September, if they miss the rent from that point in period,
Right.
what options does a homeowner have to recoup that money? And if the tenant is not paying from September 1st through January 31st, how are the options different in that situation? Because I almost get a sense that the bill is like twofold. It's from March to September, and then from September on to January 31st.
Yeah, exactly. The differences are that you can't require the tenant to make any payment for the March to September rent at all until the legislature decides what's going to happen on February 1st. And I have a feeling, I mean, you're talking 10, 20, or $30,000 of rent that's accruing. Are they going to make the tenant pay all that on February 1st, 2021? I doubt it. I really doubt that. There's all sorts of proposals that are being floated around. I mean, some of the proposals are a 10-year repayment period. So they might have to pay their normal rent on February 1st and then 1/120th of the back rent every month on top of that. That's one thing that could happen. Or who knows, maybe the government's just going to say that you don't have to pay it at all. I mean, which I think is going to be the reality. Most tenants are probably going to skip out and never pay it. That's the actual truth of what's going to happen with most of these tenants who are so far behind on rent. But the only difference is from September 1st onwards, you can require the tenants to pay 25% of the rent. But again, the law doesn't require that to be paid until February 1st. So on February 1st, if they're not even paying the 25%, I have a feeling that those people will be subject to eviction. It raises the great uncertainty of what's the law going to be on February 1st. We don't know. We just don't know. So there's the answer to your question on that.
So essentially, they're required to pay 25% on February 1st, but it doesn't have to be monthly payments. That balance has to be paid. Now, what happens if they don't pay that balance? Oh, that's what you're talking about. That it could change at that point, or what happens if they don't pay February 1st the 25% that they owe?
Right. I mean, September, October, November, December, January, that's 5 months during which the time they only have to pay the 25%. So that, they only have to make a single 125% payment on January 31st, and they're fine under the current law because they don't have to pay it monthly. And one thing that strikes me as really weird is that the laws all say the tenant owes the rent. There's no doubt the tenant owes the rent. The government's not forgiving the rent, but the landlord has no way to collect it. Even if you get a eviction judgment against a tenant for one of the reasons that I talked about, you're not allowed to get any of the money, owed part of that judgment. So you can't start garnishing paychecks, hitting bank accounts, doing the normal things that I do to collect money for my landlord clients after we win an eviction case. I can't do those right now. It's just enough to get control of the house back with $0 owed. That is something that the legislature is foreseeing as far as the money, which is they're going to have enhanced small claims. In other words, if you're right now, a small claims court only goes up to $10,000. Sometime in like March or April, I forget which one, they're going to allow small claims to go up to an unlimited amount as long as it's only for rent. But is that going to change too? Who knows? And how likely is it? Let's say that you get a judgment against a tenant for $30,000 because they haven't paid you rent for a whole year. I mean, $2,500 a month rent times 12 months. Guess what? That's $30,000 right there. You get a judgment for $30,000 in the enhanced small claims procedure in March or April of 2021. Good luck collecting that. It's really hard to collect money from someone who doesn't want to pay you. I mean, I'll tell you my track record over the 20 years. I collect maybe 10% of my judgments. That I might collect. That's the first penny. I rarely collect the whole thing. It's hard to collect money on these things. Yeah. So the reality is a lot of these tenants are never going to pay, and so the landlord needs to be looking at that with their eyes wide open.
So let's go over the options that the landlord has. So, for example, like let's say that you want to sell your property. What type of notice do you have to give the tenant, and what does that process look like? Let's say that they end up entering into an agreement with an owner-occupied. So, what's the first notice? And I hear that you have to give them the coronavirus form, otherwise everything else kind of is irrelevant. So, kind of explain that to us.
That's a great way to start off this discussion, which is there's only one form that I'm using right now, and I'm going to show you this form. Let's see here. So if you all can read that, Notice of Termination of Tenancy, COVID Tenant Relief Act. There it is. This is a CAR form. It's the only form that I use, and it's 3 pages long. The last page is just the proof of service, but the specific issue is, you have a house, or a condo, you want to sell it, the tenant's probably not paying you rent, or paying you very little rent, and is way behind. That's the situation that I would say is the most common situation that I get right now. And I tell my landlord clients, you have one of two options. The first option is you check the 60-day box for owner intends to withdraw the premises from rental market. That's 60 days. That's valid and legal. The second option is you actually enter into escrow, and then you check the 30-day box, but you have to have an escrow started. Well, guess what? It's hard. You can tell me this better than anyone. Is it easier to sell a house that's empty, or is it easier to sell a house that has a tenant in there who's trying to stop you from selling the house? So
it throws some difficulty in this whenever there's a tenant in.
Even a nice tenant would throw difficulties in it. But if you have a difficult tenant who's doing everything he can to fight against you, the landlord, that's going to make it really hard. But guess what? People are doing it. The real estate market is red hot right now. Everything that I see going on in the market is getting sold within days with multiple offers. And you can confirm that or not confirm that. But people, if you have an attractive property and you're willing to maybe shave a few bucks off the listing price just to get it sold, you could probably get into escrow with someone who has very limited access to the property because there's a tenant living in there. And then you would only have to give 30 days notice.
One of the recommendations I would make if you're a real estate agent and you're basically helping your client is just, if there's a tenant in there that's not paying rent, assume that they're going to become uncooperative at some point. So if you assume that they're going to become uncooperative at some point, you can basically take precautionary methods to try to put yourself in a better position to be able to close the deal. So like, I'll give you an example. Like, we had a tenant that actually allowed our photographer to go take pictures and allowed us to take the 3D Matterport tour. There's like this whole piece of technology called the 3D Matterport tour. I almost knew that this was going to be like a one-shot type of thing, meaning that like at some point this tenant was going to become uncooperative and say, hey, look, you can't enter the property or whatever reason. So I'm so glad that I did the 3D tour, because what we were able to do is we were able to market the property with the 3D tour. It's the best thing to being inside the property because somebody can actually view the floor plan. And then sure enough, as soon as we open up escrow, we're ready to do inspections. The tenant basically says, hey, look, I think I have COVID. I'm in the process of being tested. I'm not letting anybody in until I know my results. So that's one of the questions that I'm going to circle back to you on that to see what kind of happens for that. But essentially, the two requirements are make sure that you give them the coronavirus a form, and then make sure that you're in escrow before you give them the notice. Or how does that work again? If you're selling the property to an owner user,
if you're selling the property, it's the same notice. You just check a different box. Then it's a 30-day notice, but you have to actually be in escrow.
Perfect. So open up escrow with an owner user, somebody that's going to occupy the property. That would allow you to sell the property, and it would allow you to regain possession back for your property, even if the tenant's not paying the rent. So essentially a way around it. Now, could somebody open up escrow and basically no, they can't. It's just kind of like basically you have to have an owner occupant buyer basically it's going to buy the property and open up an escrow. That's a requirement.
That's what the law says. I mean, could someone lie about it? I'm sure someone will. Someone in the state of California is going to lie about it, but not with me representing them. So,
let me ask you another question. So that's one of the ways that a landlord can get somebody out if they're going to be selling the property. Let's say that they're not going to be selling the property, but the tenant is in breach of their lease agreement, meaning they've got 3 dogs at the property. The lease states no lease agreement. What does that process look like? And what is the best way to document these things? Meaning like video, pictures, tenant saw them, cameras. What's the best way to document all this?
there's all sorts of different violations that could happen, like a tenant who's smoking in violation of a no smoking rule, a tenant who has a pet in violation of a no pet rule on the lease.
Mhm.
And that invokes the whole, every time I see that, the tenant says, hey, it's an emotional support animal. I'm protected by the Americans with Disabilities Act. A tenant who maybe doesn't take the trash bins in on time. Trash is collected on Tuesday. They wait until Thursday to take the trash bins in. It has to be a substantial breach of the lease in order to justify termination. I would say, one time not taking in the trash bins, probably pretty easy to prove because the landlord can take pictures of the trash bins. But I don't think that taking in the trash bins 2 days late is a sufficiently big breach to justify termination of the lease. The pets, I think, is sufficiently a big breach to justify termination, but you might have to potentially overcome the Americans with Disabilities Act thing. In other words, if the tenant shows up with a letter from the doctor saying this tenant needs this dog for emotional support, that might be enough to defeat that. I've actually never gone to court on that particular thing. The thing I have gone to court on is the sublease and assignment, which is that's a tough one. I win some, I lose some. I mean, just the last case I had, I lost. I didn't have enough proof. The proof that you need is, eyewitnesses who show you how many days a week this person is there, what times a day he's there. Do they get mail at the property? Do they have keys to the property? Do they claim this as their personal residence? These are things that are hard to prove unless you can get into the mind of the tenant or the sublessee who's living in the property. You would have to be able to like go into the mailbox and see mail is being delivered. You would have to actually see this person take a key from their keychain to open the front door to prove that they have a key to the property. You'd have to actually stake them out long enough to know how many nights a week they're living there. Very difficult things to prove, and you have to prove that with eyewitness testimony. You can't just have a neighbor submit a written declaration. The neighbor's going to have to go to court and testify. And so, like I say, those are win some, lose some. I mean, the pets, that's easy to prove. Just the whole ADA thing is the difficult part. Waste on the property, that's not hard to prove. I mean, that's easy to prove is what I should say. I mean, the tenant has destroyed the kitchen and ripped out parts of the bathroom for no particular reason. Okay, just take pictures of that. That would be a good way to show waste on the property. So, what kind of things can you show by actual human beings who will testify or take pictures? That's the kind of evidence that we need if we're going to go to court on these kinds of cases. And when you go to court, I tell all my clients this: it's unpredictable. You might win, you might lose. So be aware that even I lose cases sometimes. So it's a tough thing to go to court and potentially lose one of these cases.
Is the tenant not allowing the owner access to the property, like with a 24-hour notice, a valid reason to potentially evict?
Yeah, and that's right there in the law. I mean, it says let's see here. Refusal to allow the owner to enter as authorized by law. The law only requires a 24-hour written notice. So you post the 24-hour written notice. The tenant says, hey, you can't come in when you come at the regular time. Regular times are Monday through Friday during normal business hours, which to me means 8 to 5. So Monday through Friday, 8 to 5. Tenant, you give the 24-hour notice. Tenant says, no, you can't come in. My advice to my landlords is don't go up there and beat up the tenant and force your way in. Just leave. And then that's valid grounds to give a 3-day notice of termination. And I have taken that case. I have won that case. That's a pretty easy case to prove. You just have two people, and tenant says, "Hey, you can't come in." We got him. Which a lot of tenants are stupid enough to make that mistake. So that's a good ground to kick someone out. A fairly easy ground to prove.
But document it, right? Like have some proof essentially to cover your tail.
The last time I did this, it was just testimony. We didn't have video or anything. Well, we took the video with our cell phones because everyone has a cell phone, but the court didn't even require it. We just had our witnesses testify. The tenant actually got up on the stand and said, "Yeah, I refused to let you guys in." So that was the end of our case. We didn't even have to get the video out. It was beautiful.
Wow. Okay. Now somebody's asking, one of our viewers is asking, if a landlord knows that their tenant is currently employed and receiving income, but the tenant does not pay rent from March to September, do they have any options for eviction due to non-payment?
No. All the tenant has to do is sign the declaration. The declaration does not have to be true. If they sign the declaration, the tenant automatically wins. So there's my short answer to that very and I hear that question a lot. I understand where the landlord's coming from. That's my,
Now the
your way.
Now, the only exclusion to that, Brian, would be if a tenant makes more than 130% of the
Yeah,
median income, but you would need to have
correct,
proof of that, right?
correct, correct. Correct. So, and that's a very good point. That's exactly what the law says. I've never gotten to that point yet. I wish I could tell you more about that, but that's exactly, if the tenant makes 130% of median income, which is about 100,000 to 120,000, you can require that tenant to give proof. And if the tenant doesn't give proof, then that's potentially a way to evict that tenant in court.
Yeah. So
That's
the only thing that I would recommend to people, like when you're renting your property, knowing that like history tends to repeat itself sometimes. If you're renting your property and you know that your tenant is a high income earner, you might want to collect some of that information up front and keep it on record for your application in case something like this were to happen in the future. You've got that proof. And now that gives you an additional option if you're in a situation where maybe the tenant is trying to take advantage of the law. You know that the tenant is working, you know that the tenant is making income, but they're declaring that they've been affected by COVID-19, that might be a workaround, and that's something that you can do at the very beginning of of the lease. Now, let me ask you this: what if somebody like a tenant? We have a tenant, we're in escrow, and now the tenant is saying that we can't enter the property because they think they have COVID. But I've heard this so many times already that I think that some people are basically overusing it or using it when it may not be the case. So,
yeah.
like, what can a landlord do in that situation?
I'm confronting that issue quite frequently, and my position is Civil Code Section 1954 says the landlord can enter upon giving 24 hours written notice. Um, and we're simply following the law. The law doesn't provide that doesn't apply if the tenant is sick. I tell my landlord clients to have them or their people who are coming over to make sure to wear a mask, to wear gloves, and to follow some basic safety protocols like that. But the tenant doesn't get to automatically avoid the law by just saying COVID, and we're proceeding on that basis, and it's never a problem. It's just usually used to intimidate the landlord into doing nothing. That's usually what happens. My advice to landlords is just go ahead and do your inspection, make sure you're appropriately wearing personal protective equipment, and don't let the tenant tell you what to do.
So basically, it's enter at your own risk. Basically,
Oh
like
yeah,
if he's saying that he's got COVID, you still have the legal right to enter.
definitely,
Enter at your own risk. In other words, so still provide the 24-hour notice to the tenant, enter the
yeah.
property as long as they don't. Now, can somebody force themselves in a property?
No, I would never advise, like I said, I was joking before, the landlord cannot beat up the tenant in order to get into the property. If the tenant's sitting there physically, just all the tenant has to do, you're not coming into my property, old arm. My advice is you will not lay a finger on that tenant. You're not going
Well,
to,
the reason I ask this, Brian, is I have clients that they get so heated, they're landlords, and they get so heated, and like, I'm just going to go in there and do this or do that, and it's my property. I'm going to get in there, and I'm like, look, if the tenant stands at the door and he says you can't force your way in there, don't even try it. Don't do it. You're going to get yourself in a bigger mess. But like they get so amped up, and I'm just like, dude, don't do it. But they think that they have the right to actually do it because they're the owner of the property, that they can force themselves in there. And my advice is not to do it, but I'm glad to hear that you're basically on the same
yeah,
about that. Now, let me ask you this. This is more like of a different type of concern. Like, what if like could somebody, like, let's say that we enter a property and I mean we're good, we don't have any symptoms, but then a tenant gets sick 3 days later and now blames us entering the property with a 24-hour
yeah.
notice. Like, is there any liability to a landlord in that case?
You
Like, they
know,
saying like, you got me sick because you entered my property. Now I'm sick. Now I have COVID. They'd have to prove that
yeah.
to
And
right.
how are they going to prove that? I mean, if you don't have COVID yourself, how are you going to give COVID to someone else? I mean, it's in the United States of America, anyone can sue anyone else for anything. So be aware that your tenant could sue you. I wouldn't be afraid of that. I just never see things like that happen. The tenants, it's very rare for a tenant to sue a landlord for anything, especially if the landlord's being somewhat reasonable. Wearing your mask, wearing the gloves. There's just no way that that would ever get proven. But that leads me to another piece of advice for my landlord clients, which is make sure you have a good insurance policy on your property, because that will protect you against a lot of tenant claims, including this potentially. I mean, your normal property insurance policy is going to be costing you $600 to $800 a year. In addition to which, this is something I love to tell people: get an umbrella insurance policy. I personally have a $2 million umbrella insurance policy. It costs me like $350 a year. Get good protection, which is the best advice I can give to you to prevent against lawsuits like this. Lawsuits like this are very rare, but if you have insurance, the insurance should cover you for any such lawsuit.
Okay. So I have got two more questions, Brian, and then I'm going to let you go. The first one is, so like, let's say that you're evicting somebody because of they have a pet, and then
Right.
you give a 3-day notice because they have a pet. What's the step after that? Do you have to go back to the property and confirm that they don't have a pet, and what happens if they don't have the pet anymore, and what happens if they do have the pet?
Yeah, if they normally in that sort of situation, I would say it's a 3-day cure or quit. So if they get rid of the pet in 3 days, then they should be good. If they don't get rid of the pet and you come back and you take a picture of the pet sitting there in the backyard, I think that's good evidence that the tenant's in breach. And then you can start it. You don't have to give any further notices after that. You can start the eviction lawsuit immediately afterwards.
Okay.
And just for everyone's benefit, the eviction lawsuits, what do they look like? This is what I do all day long. Usually they take about 30 days under normal circumstances. In today's COVID environment, we're looking at more like 45 to 60 days. The courts are a little slower, a lot slower. So 45 to 60 days is the time frame that I'm telling people for an eviction case. My normal fee is about $1,500. So that's the time frame, that's the cost that you're looking at to actually evict someone with a competent lawyer like myself. I mean, there's some crazy lawyers that'll say they want $10,000 to evict. Don't go with someone like that. Go with someone who knows what they're doing, who does this all the time, does a good job, does it for a reasonable price. That's the best way for landlords to proceed in this sort of a situation.
Okay, perfect. And I'm glad that you kind of shared that with us. So let's say that you win the case on an eviction.
Right.
How long does it typically take to get the tenant out from that point?
Right. So the time frame that I gave was 45 to 60 days. It takes about 25 days from the time that you start the case till when you're in court. And let's say that you win in court, the sheriff has taken about 30 days. So from the day that you win in court to the day the sheriff comes, 30 days. So that's about a 55-day timeline right there.
Okay.
Normally it's 10 to 12 days. Right now the sheriff's giving people a lot of extra time so that they're mitigating against any COVID exposure. They don't want people to become homeless. So, a tenant who does everything wrong still is going to get at least a month and a half, 2 months before they're actually evicted by the sheriff. And this is another educational point for all your viewers, which is, the sheriff comes out, they have firearms, and they draw their firearms, and they knock loudly on the door, and they say, "Tenant, you must leave right now." And if the tenant doesn't open the door, we have a locksmith that picks the lock, opens the door. The sheriff goes in and uses physical force, if necessary, to kick out the tenant. That's what an eviction is. Most people don't want to fight against sheriffs who are holding guns. They leave at that point, or they leave even before the sheriff gets there. So that's the end point that these evictions come to. And those are happening in Ventura County right now. I mean, a lot of landlords think the tenant, there's nothing I can do to a bad tenant. I can assure you, I am evicting people right now. I have about 20 active cases. I had about 30 active cases a month ago, but I'm pushing them all to conclusions that are successful. And, if you need advice, get advice from the lawyer who knows what he's doing, who does this all the time. And, find out what your rights are. Find out what your options are. Be smart if you're a landlord. Don't take your advice from your Uncle Manny. Take your advice from Brian Nomi, the guy that does this all the time. So that's some good advice for landlords. I hope that you'll take it. And by the way, I'm the only lawyer in the world who answers his own phone. I never charge for phone consultations. If you need a 30-day notice, a 60-day notice, a 3-day notice prepared, I prepare those for free. So that's something that I offer to every landlord out there. Just get the right advice, talk to me for free, and find out what your real options are before you make a decision.
Yeah, and then we'll post your phone number on the bottom of the message as well too, in case people want to reach out and just try them out. So if you're in a situation like this, my advice would be just to know your options, because it varies based on different situations. And based on your situation, the advice might be different, which is why you want to talk to somebody that has expertise. The last question that I had looking back at my notes was about the 15-day notice. So when does the 15-day notice apply, and what happens after the 15-day notice?
Yeah, the 15-day notice is something that you give to a non-paying tenant. In other words, it's a 15-day notice, which you have to give along with the notification of tenant rights and blank declaration. So the tenant has 15 days to read their rights and potentially return the declaration saying, my income has been impacted by COVID. I can't pay the rent, or I can only pay 25%. Or if they're a high income tenant, they have to give proof that their income has been impacted. So after the 15 days expires, then the landlord has to give another final 3-day notice to quit after the 15 days, and then you can file an eviction case due to non-payment. And as I've said earlier during this interview, I'm seeing 0 cases for non-payment of rent right now. No one's doing it. It's just too easy for the tenant to defeat them. I mean, I'm sure someone somewhere is doing it, but it's just the rent issue is a complete non-starter. But that's what the 15-day notice is.
Brian, I enjoyed our time together. I think that you provided a lot of good information. I think a lot of people are going to benefit from this information. Where can people get a hold of you if they are in a situation like this, or they have some other questions for you?
I'm really easy to find. If you just type my name into Google, you'll find my website immediately. It's briannomi.com, BRIANNOMI. Let's see if you all can read that. That's my website right there with all my contact info. briannomi.com is me. I answer my own phone. I deal with my own email. I do have an assistant who I was gesturing to a little while ago, who works with me here. I'm happy to answer phone calls and just get people the right information. And before we sign off, Jose Luis, I wanted to say I just love your videos. Your YouTube channel is great. I've learned a lot by watching it. I love the public service that you're doing to the community to get people educated. Very nice job on your part.
Yeah, no, thank you. I appreciate that. My thing is, I feel that the more I educate people, the better their decisions will be if they have the right information. So I'm taking it upon myself to get the right guests like you on here to basically provide the right information out there for them so that they can make some good decisions.
Great.
All right, Brian. Well, thank you so much. This was episode number 44 of the Morales Group. If you liked it, feel free to subscribe, hit that like button, and feel free to share it with anybody that might be helpful. We'll post all of Brian's information down below. The other thing that we're going to do is we are actually going to post the notice of termination of tenancy form on the attachment for the video. We're also going to post a great document that Brian sent me from the Association of Realtors in regards to the changes for rent cap. It's got a lot of Q&A where you can get your commonly answered questions. And then California Apartments Association also has a different little booklet that we'll post as well too, in case you read up on the knowledge. And then anything else, Brian's always available. As I mentioned to you, it's a case-by-case type of thing. So reach out to Brian. Thanks again. And we look forward to the next one.
All right. Thanks for having me on.